Hello. Good afternoon, Charlotte. Hi, good afternoon. I'll just wait till one or a couple more people join in. We'll get started. Hi, John. Good afternoon.
Hello, Rabbi. How are you?
Okay, good. Thank God. Well,
Good. Fine. Thank you.
is
Hello,
the screen
Sarah.
up? Can you see the screen there?
Can see it. Yeah. All good.
Okay, it is one, but let's give it another minute to see if some of the other regulars log on, and then we'll get started. There you go. Hi, Kent. Good afternoon.
Hello, Kent.
Hi, Rabbi. Hi, John.
Hi.
Hi. How's Charlotte? How's John? You know how's Jeff doing?
How's Jeff doing? I don't know. What? I haven't heard anything about Jeff. I was away last week. Okay. What happened?
I understand he wasn't well. I just wasn't sure.
Oh.
Sorry, Rabbi. Please continue. Apologies.
Okay. I think we're ready to get started. There is always a recording for those who are late. They can go back and check into the recording. So we're studying the laws of Shvuot, of oaths, and we have to chapter 9. Now, right at the outset, the Rambam shared with us 4 categories of oaths. There's a false oath. There is like a useless oath. There's oaths that relate to when I've got something that belongs to you in my property. And then there is what's called the Shvuas Eidut, which is an oath about testimony. Now, as we'll see here, as we saw similarly when it came to, for example, we discussed yesterday in detail, the Shvuas HaPikadon, that there are certain types of oaths that you may take for which you will not be liable strictly for a Shvuat Pikadon, but you may still be liable for taking a false oath. So similarly here, the definition of Shvuat Eidut is very precise. In fact, the Rambam is going to tell us that there's 10 conditions in order for you to violate a Shvuat Eidut. Anything other than that, you may be lying, you may be liable for another type of Shvuah, false oath, but you won't be liable for Shvuat Eidut itself in particular. Okay, so that's really the theme of today's chapter. And of course, the difference will be is what the consequence for your misdeed is. If it's a Shvuas Eidut, there's a certain type of korban that is bought. If it's a Shvuas Bitui, there are other consequences or a different type of korban that you would bring. And that's why we need to define precisely what is a Shvuat Eidut. So basically, what is the Shvuat Eidut? We'll see that there's 2 steps. But in a nutshell, and we'll see it as we learn through the halachot over here, is that let's say I come to you you and a friend of yours, and I say to the two of you, because Edut must be two witnesses, right? I say to you guys, listen, I know that you have, you will witness to a transaction, and so owes me money because of that transaction. And then you deny knowing of the event, and you swear that you then go on to swear that you cannot testify. So it's those two steps that require you to be liable for shvuat edut, and we'll see a number of other particular details are required. But essentially, you must first deny that you have the information, and secondly, you must then go on to swear that you don't have that information, and therefore you cannot provide testimony. And of course, we're talking about in a situation where it's apparent that you do have that information and you're lying. So then you've transgressed this shvuat edut. Okay, so let's look at the halachot itself. When a plaintiff demands that witnesses testify concerning a matter that through their testimony alone will obligate the defendant to pay this plaintiff a financial claim involving movable property, the witnesses denied knowing testimony. Already the Rambam said a few points over here. He says it must be something that your testimony alone will ensure that the payment will be made. It must be testimony about movable property. And then the witness denies knowing the testimony, and then they take an oath to this effect. Now, here's the thing, whether in court or outside of it, if they take this oath, they say, I swear that I do not have, and obviously with Hashem's name, as we've said previously, or some other reference to Hashem, that I do not have information to testify. Whether they take that oath in the court or outside of the court, they are liable for the shvuat ha'edut, as we've described it. Why is this? What is their liability? Because when the conditions are met as described, they cause the plaintiff a financial loss through their denial. Similarly, if the plaintiff administered an oath to them and they denied the matter, they are liable even though they did not take an oath or answer amen to the oath he administered. Since they denied the matter, they are liable provided he administered the oath to them in court. Okay, so here we have a distance. If they take the oath themselves, swearing that they don't have testimony, that oath can happen inside court or outside of court. If the plaintiff says, I swear that you do have this information, even if they don't say amen to it, and then they refuse to testify, or they just deny it, they say we don't know, it's as if they've sworn falsely. But that, if the oath is being taken by the plaintiff in a reference to them, that must take place in the court. Okay, halacha 2. The witnesses are not liable for shvuat ha'edut unless they deny knowing testimony in court. So though in the previous halacha we said the oath can take place inside of court or outside of court, but the actual denial of their knowledge must take place in court. And the reason for this is because because the liability, remember, is because they are now causing this plaintiff to lose money. Now, here's one of the things about testimony in the court. If I walk into a court and I deny that I have information about a certain case, I'm not allowed to retract that. I'm not allowed to retract that. If I then go ahead and take an oath that I don't have that information and I'm lying, so I'm liable, as we said, for shvuat edut. But if, let's say, the guy comes to you, the plaintiff, he says, hey, Yankel, you have testimony. I know that you were witness to when I gave Beryl a loan, and I want you to come and testify me. And Yankel says, no, I know no such thing. So if that denial happens outside of court, he hasn't actually precluded himself from eventually being a witness. Because theoretically, he can still go to court if he gets persuaded to, and actually give that testimony. So the denial of the knowledge must take place in court because it precludes him from ever actually offering testimony again. But then if he takes the oath to the same effect, he'll be liable for the oath. Now, whether they took the oath or the oath was administered to them in court or outside court, the denial must be in court alone. That's the emphasis of this halacha. Because as the pasuk says, if he will not testify, he will bear his sin. And it implies that in the place he will testify, and that testify will have an effect, testimony will have an effect. There, if he does not testify, he will be liable. Again, so he's saying, denying it outside of court does not, again, preclude him from eventually coming forward that information and testifying to it. But denying it in court is what precludes him from ever testifying. And therefore, if he then swears either inside of court, either himself, or he responds to somebody, he then will be liable. Halacha Gimel. When the plaintiff demands that the witness testify concerning a claim that does not involve a financial obligation, so concerns about landed property or servants or promissory notes, and the guy says he denies knowing, and he takes an oath to the effect that he doesn't know about, this is not a shvuat edut. Again, he might be lying. He may be liable for some other type of shvuah, some type of false oath, but not for shvuas edut. For they are only liable when denying testimony concerning financial claims that resemble an entrusted object, a financial deposit, a robbery, or a lost object, which the verse mentions in the passage. In other words, it has to be something of monetary value and is movable. But if it's testimony about anything else, it's not subject to this particular type of edut. So he says this refers to movable property, which is itself of financial worth. That were they to testify, this is the point, were they to testify on the plaintiff's behalf, the defendant would have to pay. So what else will this rule out? Similarly, when one administers an oath to witnesses who can testify regarding a fine and they deny knowledge of the matter, they're not liable for shvuat ha'edut. Okay, remember, for example, there's times when somebody steals. So he has to pay the principal, that's the repayment, but then there's the knas, there's the fine. So if the testimony that we're asking about is with regard to a fine, that's also not a shvuat edut if they deny knowledge about it and they swear to that effect. Okay, he would not, and the reason is, this is the rationale. Sorry, I lost my place. He would not be allowed to even, the rationale is that were the defendant to come and acknowledge his liability for the fine first, he would not be liable to pay, even though the witness came afterwards and testified accordingly. Remember, we learned previously that if somebody is made the knas, if somebody admits that they owe a fine, they actually free themselves from that fine. So because it's not the testimony alone that would cause the plaintiff to lose money, but also the admittance of the guy that he's making a claim against would also cause him to lose money. Therefore, this type of oath is not considered a shvuat edus. Thus, the witnesses did not make him liable through their testimony alone. Instead, it was their testimony together with the denial of the defendant that made him liable, since their testimony would not be effective if he acknowledged his liability. If they denied knowing of the matter and took an oath, they are not liable. Again, the point is, it's not upon their testimony alone that would cause the plaintiff the loss of his money. The plaintiff may very well lose his money simply by the guy that he's claiming against admitting to his fault. And therefore, it doesn't fit into this category. When a plaintiff administers an oath to witnesses saying, I am making you take an oath that you come and testify on my behalf that so-and-so owes me a double payment or a 4 and 5-fold payment, and the witness denies knowing the matter, they are liable for shvuat ha'edut because of the principle, which is a financial obligation, but not because of the double payment, which is a fine. We had a similar halacha yesterday with the shvuas pikadon. Basically, you can either be swearing about a principal amount or about a fine amount, or sometimes you might be swearing about both. In this instance, that's what we're talking about. The guy says, so-and-so owes me a double payment. In essence, what you're saying is he owes me a principal and a double payment. So if this possible witness now denies that and swears to that point, they would be liable for shvuat ha'edut. And again, not because of the fine component, but because of the principal amount component. Similarly, if they administer an oath that they testify that so-and-so raped or seduced his daughter, and they deny knowledge of the matter, they are liable for shvuat ha'edut because of the payment due for the embarrassment and damages. Again, this is a scenario that we mentioned previously, without going into the details of this law. But if a young girl is raped, so there's two components here. There is what the Torah administers as a standard fine, which was the 50 shekel, but there's also the amount that the individual has to pay for the aspects of the assault, the wounds that he's caused, the shame that he's caused. And because you've got two amounts, you've got one amount which is actually a payable amount and one amount which is a fine, and they now deny it, then that would be a shvuat ha'edut that he would be liable for. Why? Because if the defendant acknowledges obligation, he would have to pay these obligations, but not because of the fine, which he would not have to pay if he admits. Similar law applies in all analogous situations. In other words, where there's both a principal payment and a fine payment, and the possible witnesses deny their knowledge and they swear to that effect, and they're lying, they would be liable. Halacha 6. Witnesses are not liable for shvuat ha'edut until they deny knowledge of the matter and take an oath after the plaintiff or his agents demand that they testify. Again, so this whole thing has to be in response to the plaintiff coming and asking that they testify. If, however, they take an oath first before a demand is made of them, they are not liable for shvuat ha'edut. What's an example? The witness saw the plaintiff following after them and they told him, "Why are you following us? We are taking an oath that we do not know any testimony about you." They're not liable for shvuat ha'edut, and the rationale is that the plaintiff did not make a demand on them. Instead, they took the oath first on their own initiative. Again, they might be lying and they might be held liable for other reasons, but it's not the definition of shvuat ha'edut. Similarly, if the defendant administers an oath to them that if they knew testimony involving the plaintiff, they should come and testify, and they deny knowledge of the matter, they're not liable for shvuat ha'edut unless the plaintiff makes them take the oath. Needless to say, if they administer an oath that they should come to testify that so-and-so owes so-and-so money, in other words, it's not the person himself, but it's a third party, and they deny knowledge of the matter, they're not liable. For the person making this demand is not the plaintiff himself. So again, it must be a claim must come before the denial and the oath, and the claim must be from the plaintiff himself. Similarly, if the oath preceded the knowledge of the testimony, they are not liable for shvuat ha'edut. As the verse says, and he heard the voice of an oath when he was a witness. Which means it can be inferred that the knowledge of the testimony precedes the oath, and not that the oath precedes the knowledge of the testimony. What's the example? How would that happen that I would take the oath before I know the information? So he says, if the plaintiff says, "I'm administering to you an oath that if you will know of testimony concerning me, that you come and testify," and the witness responds, "Amen," and afterwards, then they observe a matter concerning him. They see him lending money or something. So if he demands that they now testify and they deny knowledge of the matter, they're not liable for shvuat ha'edut, even though previously they had sworn that they would testify on his behalf, because again, it happens out of order. The only time you're liable for shvuat ha'edut is if the events took place, the plaintiff comes to ask you to testify, you then deny the testimony, your knowledge, and you swear to that effect. All those conditions need to be in place. Halacha 9. Witnesses are not liable for shvuat ha'edut until the plaintiff singles them out, administers oath to them, or they take an oath. So it has to be that the claim must come from the plaintiff and it must be directed to them specifically. So what's implied? So for example, if a person stood up in a synagogue and he said, "I'm administering an oath to anyone who knows testimony concerning me to come and testify on my behalf." So in other words, there's a guy who had a transaction. He knows there were witnesses. He doesn't remember who they were, or he doesn't know where to find them. So he's running around town, going to every shul, and he's making these pronouncements because he's hoping that they're somewhere inside the shul. So he says, "I'm taking oath. Anyone who knows testimony about me should come and testify on my behalf." Happens to be that the witnesses are there. And they respond, "Amen." And then afterwards, he demands of the witnesses that they testify. And then they say, "No, we don't know anything about it." Which means, in effect, they've agreed to an oath, and now they're denying it, which would seem to be that they have taken a false oath. But he's saying in that situation, they're not liable for shvuat ha'edut. Why? Because he did not single out the witnesses individually. Okay, and what we're going to see next point that is that it doesn't actually have to single them out particularly, but he has to single out the group particularly. If he said, "I'm ministering an oath to all of those standing here, that if they know testimony concerning me to come and testify on my behalf," and then the witnesses are amongst those present, and they deny the knowledge of the matter afterwards, then they are liable for shvuat ha'edut because he singled them out amongst the others. In other words, here we're talking about a particular type of phrase. If somebody comes and he says, "Anybody who knows something should come and testify." But if he comes into shul and he says, "You who know something, you standing before me, who knows something must come and testify for me," and the two witnesses are there, and then they deny knowing it, then they would be liable for shvuat ha'edut. Similarly, halacha 10. If he told the witnesses, "Come and testify on my behalf that so-and-so owes me a money," and then stands in a synagogue and says, "I'm administering an oath to anyone who knows testimony concerning me to come and testify on my behalf." In other words, he was walking to shul, he saw the two guys that are witnesses to him. He says, "Come and testify for me." Then he goes in and saying, "Anybody who knows must testify for me." And then they refuse to come and testify, they are liable because he made a demand of them previously. So even though when he stood up, he says, "Anyone who has information should come and testify for me," because he had singled them out previously, they would be liable if they now refuse to or deny knowledge of the events. But this applies provided they are present in the synagogue and a court is also there. Remember, is the denial has to take place in the presence of a court. So that would be the additional conditions here. If a court was not present, they're liable for shvur. If the court was not present, they are liable for a shvur ta'edut if they answered amen, and then deny the matter while in a court of law. But if they did not answer amen, they are not liable because they had not yet denied it in a court of law. Right? Remember, the denial has to take place in front of a court. The oath can then take place either before a court or outside of a court. Okay, halacha 11. Whether one admits his oath to his witness or tells them, I am commanding you with an oath, or I am binding you with an oath, in other words, different phrasing, they are liable, provided he administers the oath with Hashem's name or with one of the terms used to describe him, as we explained previously with other types of oaths. It must be certain phrase, but it doesn't actually have to be the word nishba. It could be other types of words that denote an oath, and it must have Hashem's name, but it also doesn't have to be specifically Hashem's name. It could be terms that we use to describe Hashem, like Rachum, Chanun, and so on, as we've learned previously. Halacha 12, the witnesses are not liable unless the oath is administered to them in a language they understand. Straightforward, they must understand the language. 13, so now the Rambam is going to basically summarize everything we've learned on this up until this point. Thus, we've learned that witnesses are not liable for shvur ta'edut unless 10 conditions are met. They are: the witness must be charged with testifying by the plaintiff. The matter must involve a financial claim. The financial claim must involve movable property. Their testimony alone, had it been given, would be sufficient to require the defendant to pay. In other words, if there was a way for the defendant to get away with it without their testimony, that wouldn't make them liable. Then first they must deny knowledge of the matter after the plaintiff has asked them to testify. The denial must be done in court. Hashem's name or a term used to describe him must be mentioned in the subsequent oath. The knowledge of the matter must precede the oath. It can't be that the guy says, swear that anytime you know something about me, you'll come and testify, and then something happens and then deny it. No, it has to be with regard to something that's already taken place. 9, the witness must be singled out at the time of the oath or at the time they are charged. It can't just be a general statement, anybody here. And number 10, the oath must be in a language that they understand. Okay, so those are the 10 points for which one would be liable for a shvur ta'edut. Now, although you need all those 10 conditions to be liable for shvur ta'edut, but as the Rambam goes on to say, whenever we use the expression they are not liable in this chapter, the intent is only that they're not liable for shvur ta'edut. They are liable for shvur bitui. A false oath, they will be liable for, provided they take the oath or answer amen to an oath administered by a colleague because they took a false oath. Okay, they actually have to say the oath or respond accordingly amen to an oath. When by contrast, one is liable for shvur ta'edut, he's only liable for shvur ta'edut, is not liable for shvur bitui, even though he took a false oath and did so intentionally. In other words, when all the conditions are filled, you're not liable for both, even though it's also a false oath. And the rationale is that the Torah removed the shvur ta'edut from the category of shvur bitui to make a person who deliberately takes a false oath liable for a sacrifice for its violation, just as one who took it inadvertently. What he's saying over here is really that in the category of shvur bitui, one is only liable when they do so intentionally. In the category of shvur ta'edut, one is liable when they do it intentionally and when they did it inadvertently. And so although within a shvur ta'edut, there is also a lie, a false claim, you're not liable for both because the Torah has differentiated them. He's not liable for lashes, as can be derived from what the pasuk says for one of these. A person who takes a false oath is liable for one type of oath, but not two. We do not hold him liable for both a shvur ta'edut and a shvur bitui, a false oath, right? Now, halacha 15. When the plaintiff says, I'm administering an oath to you, unless you come and testify that so-and-so has entrusted an object, a financial deposit or a stolen property or a lost object of mine in his possession, and the witness responds, we are taking an oath that we do not know any of the testimony concerning you. So again, we had a very similar halacha yesterday. Basically what we're saying is that he's listing a whole bunch of things that the guy owes him in one statement. And the witness responds, they say, we take an oath that we do not know of any testimony concerning you. So then they're only liable for one sacrifice, meaning they've only transgressed one shvur ta'edut. If they say, we are taking an oath that we do not know of testimony concerning A, an entrusted object, B, a financial deposit, C, a stolen property, and D, stolen object, a lost object that's yours and stolen property, then they're liable for each of those statements. Okay, we had a very similar halacha yesterday. Halacha 60, when the plaintiff says, I'm administering an oath to you unless you come and testify to that so-and-so has wheat, barley, buckwheat of mine in his possession, and the defendant says, we take an oath that we do not know of any testimony concerning you, they're only liable for one sacrifice. But if they say, we're taking an oath that we don't know testimony about wheat, about barley, about buckwheat, then you're liable for each of those statements. Halacha 17, similarly, if many people charge them with testifying, so a bunch of people come say, you, Reuven and Yehuda, saw such and such a transaction, and 10 people make the same claim. And what does Reuven and Yehuda then turn around and they say? We take an oath, we don't know anything about any of you people. So they are liable only for one sacrifice. But if they say, no, I don't know anything about you, Shimon, I don't know anything about you, Levi, I don't know anything about you, Binyamin. So if they're liable for each one. And as we explained, similarly with regard to the Shvuas HaPikadon. Halacha 18, when a person administers an oath to a colleague, then he knows testimony concerning him, and ultimately is discovered. Okay, so this is now the opposite, right? Somebody says, you know something about me, and then we find out that he actually doesn't know it. Up until now, we're talking about where a guy knows something and he denies that he knows it. Here we're talking about where he says he knows something and we find out that he actually didn't. So one is not liable for shvuat ha'edut. He's also not liable for shvuat bitui. Now this is a little bit subtle and complicated, because the definition of shvuat bitui is that you have to be able to say something positive or negative. You have to be able to say it in the positive and the negative. But were a person to say, I'm taking an oath that I do not know testimony concerning you, that would not be a shvuas bitui. It would actually be a shvuat ha'edut. In other words, if I say I don't know testimony about you, and I swear to that effect, what type of oath am I taking? I'm taking a shvuat ha'edut, not a shvuat bitui. So if I say I do know something about you, and I find out that I lied, and it's found out that I lied, that's neither a shvuat ha'edut nor a shvuat bitui, because a shvuat bitui is only something that can be said both in the positive and the negative. So you end up having basically a liar, but that does not fit in any of the categories of false oaths. Hence, since the negative dimension of the statement is not a shvuat bitui, the positive dimension, taking an oath that he knows testimony, is not a shvuat bitui. What happens? The guy's a liar, but he doesn't fall into any of these particular categories. Halacha 19, final halacha in today's chapter. It's clear that when a person takes an oath to a colleague that he testified on his behalf, and he did not testify, or that he did not testify, he takes an oath that he testified on his behalf and he hadn't testified, or he says that I didn't testify and he had testified. So in that case, he's liable for shvuas bitui, but there's no connection to shvuat ha'edut at all. In other words, even though it's about testimony, it's not the definition of a shvuat ha'edut. Okay, so that brings us to the end of the chapter. I hope that was clear. Some of it's a little bit technical, although we've had similar technicalities in the previous halachot. So yeah, I'm happy to take one or two questions, and then we'll wrap it up.
Rabbi, I actually asked a similar question yesterday in regard to the Shvuat HaPikadon. In regard to the two that we're up now, in regard to the Shvuat that we now